Hello everyone, my name is Scott Aubrey. I am the owner of Aubrey Law. We are an estate planning law firm, and I am so happy to be here with you today. And today I'm going to talk about 5 things you can do with a revocable trust that you can't do with a will. But before I get started, if you have any questions about what I talk about today, or any questions about estate planning in general, you can go to estateplanningmeeting.com and schedule time to talk with me for free. Again, that website is estateplanningmeeting.com. You can go there, you'll see my schedule, pick the time that works best for you, and I'll be more than happy to answer any questions you have regarding estate planning. So today's topic is 5 things you can do with a revocable trust that you can't do with a will. So a lot of times when clients come in for a meeting with me, I go over kind of what the basics are of an estate plan, and we talk about potentially adding a trust to their estate plan. And one of the questions always is, well, why do I need the trust? What can I do with a trust that I can't do with a will? And today I'm going to talk about 5 things that you can do with a revocable trust that you cannot do with a will. The first thing you can do if you have a revocable trust is you can avoid probate. And if you have a will, you still need to probate that will, and so any transfer of any assets according to that will have to go through probate. However, if you were to have a revocable trust, you can avoid the probate process for any assets that are contained within that trust. So you want to think of a trust as a backpack. And during your lifetime, you can put anything you want into that backpack. And you can put things into the backpack, take things out of the backpack, and during your lifetime, you control those assets within that backpack. However, once you die, that backpack gets zipped up, and now that trust controls what happens to those assets. And whatever happens to those assets, it has to be done according to the trust. So any asset that is in that backpack in your revocable trust avoids probate, because you no longer, when you transfer that asset into a trust, the trust now becomes the owner of that asset, and you are no longer the owner of record. However, the way the trust is designed is you still have full access to those assets, so you're able to use those assets as if they were your own. So there's really no change regarding how you use those assets. The only change becomes is how those assets are titled and who is the owner of those assets. And if they're in the trust, then the trust is the owner, and those avoid the probate process. They transfer immediately. So anything that the trust says, if the trust says that upon your death, whatever assets in that trust transfers to John Doe, that happens, as soon as you die. So there's no probate process. You don't have to court approval. You don't have to get, have the personal representative be appointed and do all the conditions and things you need to do regarding probate. The next thing that a trust can do that a will cannot is create some asset protection. And as I'm talking about asset protection, it's for your beneficiaries, but not you. So when you create a revocable trust, it does not provide you with any asset protection. So if something were to happen to you and someone were to sue you or initiate some sort of claim, or a creditor initiates a claim against you, your trust would not give you any protections. However, once any assets held in that trust, and once you die, that trust becomes irrevocable, meaning it can't be changed. So what that does is that offers your beneficiaries of that trust some asset protection. That would be in case of divorce. That would be from creditors of bankruptcy. If they were in a car accident and they were get sued by someone, they wouldn't be able to touch the assets held in that trust if the beneficiaries do not have access to those assets. So really what the great thing about a trust that will do for your beneficiaries is it provides them with some asset protection that if you only have a will, what happens is that they receive those assets outright, and there's no protections on those assets whatsoever, so they can be attached by creditors, anybody who, ex-spouse, whoever that may be, that has a claim against that beneficiary. Those assets are not protected. However, if they're in a trust, they do have some asset protection. The third thing you can do with a trust you can't do with a will is you can extend the distribution of those assets. So as I just mentioned before, if you only have a will, when you die, those assets are passed to your beneficiaries named in your will outright. as long as those beneficiaries are over 18 years of age, they receive those assets free and clear of any sort of restrictions or limitations. So whatever that case may be, whatever the assets may be, that beneficiary, as long as they're over 18, they receive that outright. If you have those assets in trust, what can happen is you can dictate when those beneficiaries receive those assets. It could be they receive a portion of the trust at 35, and then another portion at 40, and then the final third at 45. Whatever the case may be, you have a lot of flexibility on what you do and how you structure it, and so that gives you some ability to extend it out over a long period of time. Maybe the beneficiaries are over 18, but they're still younger, and they may not have the maturity or financial acumen to be able to handle a large amount of money coming in at a young age. So having a trust allows you to extend that period of when they receive it, and hopefully they receive it at a time when they're able to handle it maturity-wise and make sound financial decisions regarding that. And also, too, the way that works is even though they may not have access to the trust, the trustee of the trust can always make distributions to them under certain standards. They're called the HEM standard. It's for health, education, maintenance, or support. So the trustee can always dip into the trust and say, you know what, I want to make a distribution to the beneficiary because they want to go to school, they want to go to college, they want to get a master's degree, they want to get a medical degree, for whatever the case may be. As long as they're according to those standards, the trustee can always make those distributions to those beneficiaries. So even though that the beneficiary may not be able to access this, they can still use money in the trust as long as they're according to those certain standards. The fourth thing that a trust can do is it can maintain property in a family for a long period of time. And the way this would come up in is that if you have a summer house or potentially a ski house or some other secondary home that you use for family vacations or whatnot, and you want to make sure that property stays within your family for a long period of time. So what you can do, you can put that property into trust. The trust dictates how that property is managed. It may pay taxes on pay taxes that are due on the property. It would say how it's divided, who can use it, and then say when will it be sold, when it won't be sold. So basically, you can have some control over that property, and you're allowed to keep that in your family, and also avoid a lot of the fighting that could go on, where one sibling may want to sell the property, the other sibling may want to use it, and that way that decisions are taken out of their hands, and it's something that you decide according to your trust. So that's something you can use a trust in order to maintain a family property and avoid a lot of the squabbles that could come about that. And the fifth way, benefit of having a trust as opposed to just a will, is you're able to establish generational wealth. And what I mean by that is you're able to pass on assets to other generations, not just your children, maybe your grandchildren and their grandchildren. You can create a trust that allows that to pass on, from future generations. So if you do have a lot of assets and you want to provide for not just your own children, but your grandchildren, your grandchildren's children, you can do that with a trust. You can structure such a way that it goes on for a longer period of time, and that you're able to pass on wealth to more than just one generation. So those are the 5 things that you can do with the trust you can't do with the will. Just to recap, the first thing is avoid probate. The second thing is offer asset protection to your beneficiaries. The third thing is extend distributions of those assets over a longer period of time. The fourth thing is to protect and maintain a family home. And then the fifth thing is to establish generational wealth or pass on wealth to more than just one generation. So those are a couple of things that you can do with a trust. As you can see, a lot more flexibility, a lot more options on how you distribute your assets to your beneficiaries. So it's a really powerful tool in estate planning, and it's something that people should consider no matter what their asset level is, because of the protections that it provides for you. So that's all I have for today. If you like this video, please hit the like button. If you know someone that can benefit from seeing my video, please share this with them. If you want to hear more from me about estate planning, you can subscribe to my channel. And if you have any questions or comments, please leave it in the comment section, and I'll be more than happy to answer it for you. And As always, if you want to talk with me about estate planning or any questions you have regarding estate planning, you can go to estateplanmeeting.com and schedule a time to talk with me for free. Again, that website is estateplanmeeting.com. Go there, you'll see my schedule, pick the time that works best for you, and be more than happy to help you in any way that I can. Once again, my name is Scott Aubrey. I'm the owner of Aubrey Law. Thank you for tuning in. Thank you for taking the time to watch my video. I really appreciate it, and I appreciate you. So I will talk to you again soon.